Okay, Mr. Zarnowski, you want to provide sort of an overview?
Yes, thank you, Your Honor. First observation, Your Honor, that I'd like to make is that while Wade certainly is applicable in this case and is important, the case we have is sort of Wade with a twist. In Wade, the motion to disqualify was for the trial counsel being the former counsel of the individual. In this case, there's no dispute. Gordon Silver never represented Virgin Valley Water District. So, I mean, under the Yellow Cab case, which Wade does reference, the first thing that the Virgin Valley Water District is going to have to prove to this court in order to disqualify us under Rule 1.9 is that we were former counsel. They can't get over that first bar, that first hurdle. We never represented Virgin Valley Water District. The second thing that is important in this case in terms of how Wade doesn't apply is George Benish never represented John Linetti in the civil action. This civil action against John Linetti was first brought up, which you will hear, when the second amended complaint was filed in this case, which was on July 20th of 2011. Until July 20th of 2011, the only lawsuit that was pending was Virgin Valley Water District against Michael Johnson. There was no allegations of any conspiracies. There was no allegations of bribery. There was a simple litigation between Virgin Valley Water District and Michael Johnson. It was at that point in time when there was a criminal complaint that had been filed and a civil complaint that didn't involve Mr. Linetti that our offices had conversations with Mr. Benish. Those conversations, the evidence will show, the last conversation was on July 19th of 2011. That was one day before the filing of the civil action. So Mr. Benish didn't represent Mr. Linetti in connection with this lawsuit. What the Virgin Valley Water District is trying to persuade this court and trying to disqualify us for is saying that because we had some communications with Mr. Benish prior to the time that Mr. Linetti was sued, we now should be disqualified. And I would suggest to you that that is not the evidentiary foundation of the Wade case. It is not that foundation at all. In fact, a case that is much closer in terms of what standards you should apply is Brown v. 8th Judicial District Court, which was also cited in the briefs, and there was an attempt to disqualify a counsel who was not the former counsel under a circumstance where they were trying to impute some wrongdoing to the current trial counsel. And in that case, the Nevada Supreme Court said that they agreed that you don't have to show that confidential information was actually acquired, but the test they established was that there has to be a showing of a reasonable probability that confidential information was shared with the current trial counsel. And we will argue throughout this case that it is not enough merely to apply the Wade standards under these circumstances. The Virgin Valley Water District is going to have to present to this court some evidence that we actually acquired confidential information or it was reasonably probable that we did. And in that light, this is not the first time the Virgin Valley Water District has attempted to disqualify a trial counsel based on communications with George Benish. The United States District Court right across the street 2 years ago faced the same issue, and this issue was presented to the Nevada State Bar. In Rebel Communications versus Virgin Valley Water District, the Virgin Valley Water District tried to disqualify trial counsel for Rebel Communications, which just coincidentally is Mr. Whipple. who's representing the defendant in this case. And the basis of their claim for disqualification was that Mr. Whipple, the trial counsel, then had communications with George Benish regarding a transaction at issue in that case. Almost identical situation as we have here. And Magistrate Judge Foley, in looking at that, situation, and there the attempt was to disqualify under Rule 4.2 as a communication ex parte with a represented party. So, and there was some aspect of 1.9 involved as well. But Magistrate Foley looked at this and he says, first of all, when you're dealing with a transactional attorney like Mr. Benish, and his involvement in a transaction is to draft the documents and or to participate in negotiations, that does not constitute a confidential or privileged communication at all. And therefore, since that kind of relationship and that kind of legal service is not confidential, there couldn't have been any violations. But Magistrate Foley did say that the burden on Virgin Valley Water District was to prove that some confidential communication was relayed. The real ground that would potentially exist and that Magistrate Foley did examine was Rule, is it 4.4? 4.4 that says attorneys in representing, yes it is, 4.4a, in representing a client, a lawyer shall not use means that have no substantial purpose other than that to embarrass, delay, or burden a person, or use methods of obtaining evidence that violate the legal rights of such a person. So that's what Magistrate Foley was looking at, and I would suggest to Your Honor that that's really the issue before us, not under 1.9. And Magistrate Foley clearly had indicated that what you needed to do was show that the trial counsel had obtained evidence in that case. Magistrate Foley said there was absolutely nothing wrong with the communications between Mr. Benish and Mr. Whipple, and he denied the motion to disqualify. Not satisfied with that, the Virgin Valley Water District filed a complaint with the bar, claiming that Mr. Benish violated Rule 1.6 by communicating with Mr. Whipple. Nevada Bar thoroughly examined it, and you will hear from Mr. Benish that that complaint against Mr. Benish was denied, and Mr. Benish was exonerated with no discipline imposed. So we have two cases that are as close as you could possibly get.
When was the state bar active?
I believe it was in 2012 where the final decision came out. We'll have Mr. Benish testify as to that.
All right, okay, that's good.
So we have a situation where we've got two decisions made by people who have looked at similar contacts and said that there's no violations whatsoever.
I did recall seeing that Brown case, but could you remind me of the full name and site of that, please?
Yes, Your Honor. Let me give you the Rebel Communications site too. The only one is 2011 Westlaw 677308.
That's the Rebel case?
That's the Rebel Communications v. Virgin Valley Water District case.
All right, can you give that? That was a little quick for me, so.
2011 Westlaw 677308.
All right.
Brown, it's Brown v. 8th Judicial District Court, and that is 116 NEV 1200.
What year is that one?
Sorry?
What year is that one?
That was December 19th, 2000, Your Honor.
Okay. All right.
Now, there are a couple other things that the evidence will show here, and this is, I mean, assuming we still want to look at the Wade factors, and I think they are important because I think they exonerate Mr. Benish, as well as showing how this case shouldn't even be here. And that is that the transactions that Mr. Bingham has talked to you about occurred in 2005 and 2008. Inarguably, Mr. Benish was general counsel then. But as I said, there's already been a court that has ruled that that kind of legal work is not confidential communications. I mean, you have your own chance to decide that as well, but I think the precedent is on our side. But understand that in or about January of 2010, George Benish severs his relationship with Virgin Valley Water District. He's no longer counsel in 2010. It was not, according to the complaint in this case, it was not until August 17th of 2010, 8 months after George Benish severs his relationship with Virgin Valley Water District, that the Virgin Valley Water District claims that it first learned of the facts that support its causes of action in this case. So Mr. Benish was already gone 8 months earlier. There is no way that it is even possible that Mr. Benish could have been apprised of any facts, any strategies, or anything else with relation to this litigation when he had severed his relationship 8 months earlier. So he has no knowledge of any confidential facts relevant to this litigation. That's what the evidence will show. Virgin Valley Water District has claimed and that he must have shared confidential information with Gordon Silver. Look, in the emails that he sent to Mr. Gentile, he sent them documents. The evidence today that we will present will show that in 2009, at Virgin Valley Water District's request, all of Virgin Valley Water District's files were returned to Mr. Bo Bingham's office. So from 2009 forward, Mr. Benish didn't have any documents for Virgin Valley Water District to give us. The only documents he gave us were public documents that he obtained from counsel from Southern Nevada Water Authority. And they're public documents, not private documents. And then, again, we've already talked about how there was no second amended complaint yet on file in this case. All in all, the evidence is going to show that it is basically impossible or it will show Mr. Benish did not possess confidential information that he could have given us. You're going to have Mr. Gentile and Mr. Benish both tell you that. Or Mr. Benish is going to tell you, I had no confidential information. He's going to say, Mr. Gentile didn't ask me to reveal any. If I had any, I wouldn't have revealed it to him. And then you're going to have Mr. Gentile testify that Mr. Gentile did not receive any confidential communications from Mr. Benish, and that the only thing that was discussed was general water rights law to assist Mr. Gentile in order to defend Mr. Linetti if he were criminally indicted. So you're going to have two lawyers whose bar numbers precede mine, who are well respected, testify under oath in front of you as to what happened. And against that, all you're going to have is the Virgin Valley Water Districts maintaining a position that that every communication between an attorney and a client is confidential and privileged. That isn't the law, and I think that's the thrust of this case and how it will be decided. Do you have any questions, Your Honor?
No, that covers it.
Thank you.
I appreciate you talking about this Brown case because when I looked at the Wade case, I knew there was something else that maybe refined, even though the Brown case came prior to Wade by about 5 years or so, that sort of refined the situation because of the factual scenarios that we have here. And what I think is going to happen is it's sort of the coming together of both cases. I think the Wade standard is applicable and makes sense, refined by the idea in Brown that the reasonable probability that confidential information shared with current counsel. I mean, that would, to me, I'm going to use that to sort of refine the second prong of Wade to give it more understanding is the way I'm going to think about doing that. But during one of the breaks today, I'll look closer at Brown, so I appreciate you bringing that to my attention.
Thank you, Your Honor.